The Supreme Court just broke its silence with an emergency move that effectively hits the pause button on state-level concealed carry bans across the country. By granting an emergency injunction in a critical case, the court has essentially signaled that it is no longer willing to wait for the slow, grinding pace of lower courts while your constitutional rights are being trampled. This is not just a standard procedural update you can ignore. This is a shot across the bow that changes everything about how the Second Amendment is enforced right now. If you have been following the news, you know that state governments have been playing games by creating so-called sensitive places that turn your right to carry into a useless piece of paper. The clock just started ticking on those games, and you need to understand what this means before you find yourself caught in the middle of a shifting legal storm. If you care about protecting your rights and you want the truth without the political spin, hit that subscribe button right now, because this is where we track these changes in real time. This emergency move involves a high-stakes challenge to state laws that designate almost entire cities as sensitive places where you cannot legally carry a firearm. You need to understand that when the Supreme Court steps in this quickly, it usually means they are deeply concerned that lower courts are ignoring the clear rules set by previous major decisions. They are not waiting for a full, multi-year appeal process to play out in every single district court in the country. Instead, they are intervening to say that the status quo of simply banning carry in public parks, transit, and private businesses is likely unconstitutional. This is the part where the media is failing you, because they are focusing on the drama while missing the actual shift in power. Most outlets are reporting on this as if it is just another legal squabble, but you have to look at the practical reality of what happens when the highest court in the land puts its foot down. This emergency move creates an immediate layer of legal protection for anyone currently facing prosecution under these restrictive state laws. It signals to lower judges that they need to apply the brakes on enforcement, and it creates a massive opening for anyone who has been afraid to carry in public. However, here's the catch that most people are completely missing, and it is the part that should worry you if you are not careful about how you act. Just because the Supreme Court issued an emergency move does not mean that your local police officer on the street has received a memo or even understands what just happened. If you assume that you have an instant green light to carry everywhere today, you are setting yourself up for a disaster that no court ruling can fix for you. You need to understand that the gap between what the Supreme Court decides and what happens during a traffic stop at midnight is often measured in weeks or even months. This is exactly where you could get burned if you are not smart about how you exercise your rights in this volatile environment. Does this change how you feel about your daily carry routine, and are you concerned about how your local police will react to these shifting rules? Drop a comment below and let me know your thoughts, because I want to hear how this is affecting your view of your own safety. Here is what this means for you, specifically if you are a normal American trying to keep your family safe while following the law. Think of this legal move like a sudden change in traffic laws on a busy highway that you drive every day. Even if the speed limit is officially raised, you don't immediately start driving 20 miles over the limit because you know there are still officers who haven't updated their training. You act with caution, you keep your eyes open, and you protect yourself by not being the person who gets pulled over and becomes a test case. The legal principle is on your side, but your practical safety depends on your ability to navigate the confusion. Let's look at a realistic scenario that could happen to you tomorrow morning. You are a law-abiding concealed carrier, and you need to take your family through a public transit hub that was previously labeled a sensitive place under state law. Because of this emergency Supreme Court move, you feel confident that the law is in your favor, so you continue carrying as you go about your day. A security guard or a local police officer sees your firearm and confronts you, possibly based on old training or old laws that are still on the books. In that moment, you are not arguing with a Supreme Court justice. You are dealing with a person who has the power to detain you, search you, and potentially take your firearm. That interaction is a high-pressure situation where your goal is not to win an argument, but to make sure you get home to your family at the end of the day. You should stay calm, be polite, and identify yourself as a legal carrier, but you must be prepared for the fact that the system is lagging behind the law. If you are aggressive or if you try to lecture the officer on the Supreme Court's emergency injunction, you are turning a routine encounter into a criminal investigation. That is a mistake that can ruin your life, regardless of who is technically right in the eyes of the Constitution. You are the one who has to bear the cost of that encounter, not the justices in Washington. A second scenario to consider involves crossing state lines or moving between different jurisdictions where the enforcement of this emergency move might vary wildly. Imagine you are traveling through a state that has been very aggressive in defending its restrictive carry laws and has essentially ignored the spirit of recent Supreme Court rulings. Even with this new emergency move from the High Court, local authorities in those areas might try to keep their restrictions in place for as long as possible, using every delay tactic they can think of. If you travel there and get caught in a sensitive place, you might be arrested and forced to fight the charges in court for months. You have to be the one who does the research on the specific city or county you are entering, rather than just relying on a general nationwide understanding of the law. There is a huge difference between what is legal on paper and what is safe to do in practice when you are in a jurisdiction that is actively fighting against the Supreme Court. This is where most people get tripped up because they assume that the law is uniform across the country. It is not, and you need to be aware of the specific temperature of the legal environment in every single place you choose to carry your firearm. A third scenario involves storing a firearm at home when you might be facing a situation where local ordinances clash with federal standards. Let's say you live in a complex or a neighborhood that has tried to impose its own rules about firearm storage or carry based on old restrictive state definitions. This emergency move could potentially invalidate those rules, but it does not mean your landlord or your local homeowners association is going to stop trying to enforce them overnight. If you start openly defying those rules, you are looking at a potential eviction or a civil lawsuit that is completely separate from the criminal gun laws. You need to be very careful to keep your legal battles separate and to avoid picking too many fights at once. While it is tempting to use this emergency move to assert your rights in every direction, you have to be strategic about where you take a stand. Your home is your sanctuary, and the last thing you want is a legal dispute with your landlord that threatens your housing situation. Always check your lease, talk to an expert if you are unsure, and remember that being right is not the same thing as being comfortable. Protecting your home and your family means being smart about which battles you choose to fight. This is where the story gets much bigger, and where you need to start paying attention to the long-term political and legal fight that is coming. The Supreme Court has intervened, but the state governments are already preparing to push back with new, creative legislation that tries to bypass this emergency move. They are going to rewrite their laws, rename their sensitive places, and find new ways to restrict your rights while claiming they are in compliance with the court. This is a game of legal cat and mouse that is going to be played out in every state capital for the next few years. This is where the next fight starts, and it is the part that most people are missing when they hear the news. The legal battle is not a one-and-done event. It is a continuous, evolving conflict that requires your constant attention. You should expect to see new bills, new regulations, and new attempts to limit your carry rights under the guise of public safety, all designed to test the limits of what the Supreme Court will allow. If you think this emergency move is the end of the road, you are missing the bigger picture of how our legal system handles these intense constitutional conflicts. The bigger issue is this. The law is a living thing that is being constantly tugged back and forth between those who want to expand your rights and those who want to restrict them. You are an active participant in this process whether you realize it or not, because your behavior, your choices, and your support of different causes all play a role in the outcome. This is where people get burned, by thinking that they can just sit back and watch the Supreme Court do all the work. The court can set the rules, but the people have to hold the system accountable every single day. You might be asking why this feels so complicated when the Constitution seems so clear to you. The reason is that our legal system is designed to be slow, deliberate, and sometimes frustratingly ambiguous to prevent radical changes from happening too quickly. That is a feature, not a bug, but it means that you have to be an expert on your own rights. You have to be the one to bridge the gap between the high-level legal theory and the gritty reality of a police stop on the side of the road. That is a heavy burden, but it is the price of being a free citizen who takes their responsibility seriously. Something bigger is happening behind the scenes, and you need to make sure you are ahead of it before it hits your local community. If you want to keep up with these fast-moving legal changes and be the one who knows what's coming next, make sure you are subscribed to this channel. Let's talk about some of the myths that are currently flooding the internet and causing genuine confusion for law-abiding people. One of the most dangerous myths is that this emergency move means you don't need a carry permit anymore. That is entirely false and will lead you straight to a felony charge if you listen to it. This move focuses on where you can carry, not if you need a permit to carry. If your state requires a permit, you still need to follow that process, get your license, and carry your documents with you at all times. Do not let someone online convince you that you can throw your permit away because of a court order about sensitive places. Another myth is that you can now carry your firearm into federal buildings, courtrooms, and post offices. That is absolutely not what this move says, and it is a massive misunderstanding of how the law works. The Supreme Court ruling applies to state and local regulations, not to the federal government's rules for its own properties. You still need to obey all federal laws regarding firearms, and you should never assume that a court victory against a state law grants you a free pass to ignore federal restrictions. If you try to carry in a federal building, you are going to have a very bad day, and you will have no legal defense. A third myth is that private businesses now have to allow you to carry because of this Supreme Court intervention. People are confusing the government's power to restrict carry with a private business owner's right to control their own property. This emergency move does not take away the rights of a store owner to tell you to leave if they do not want you to carry in their shop. If you refuse to leave a private business because you think the Supreme Court is on your side, you are just committing criminal trespassing. You have to respect property rights, and you have to understand that the Constitution protects you from the government, not from the rules set by a business owner. It is incredibly frustrating to see these myths spread because they put good people in harm's way, and they give ammo to the people who want to paint all gun owners as reckless. You are better than that, and you are smarter than that. You know that being a responsible gun owner means understanding the limitations of your rights just as much as you understand the rights themselves. Do not be the person who gets caught up in a legal mess because you listen to a rumor on social media instead of doing the work to understand the actual law. When you really dig into what this emergency move means, you realize that it is a tool for your lawyer, not a weapon for you to use in your daily life. If you find yourself in a situation where you are being questioned about your carry rights, you should be polite, you should be cooperative, and you should leave the legal debate for the courtroom. You should never try to explain the details of the Supreme Court's emergency injunction to an officer who is just trying to do their job, because that is not going to change their mind in the moment. You have the right to remain silent, and you have the right to have an attorney represent you if you are ever charged with a crime. Use those rights, but use them wisely. You might be feeling a mix of hope and anxiety right now, and that is a perfectly normal response to a situation that feels like it is moving too fast. It is good to be hopeful about the progress we are making in the courts, but it is also good to be anxious about the practical risks of carrying in an environment that is still in flux. That tension is what keeps you alert, and it is what keeps you focused on the training and the preparation that really matters. Never let the legal victories make you complacent about your own responsibility to stay safe and to avoid unnecessary trouble. We have covered a massive amount of ground, and I want to make sure you leave here with the 3 most important takeaways. First, this emergency Supreme Court move is a strong signal that the status quo is changing, but it is not a finished legal battle, and you should not act like it is. Second, your daily interactions with local law enforcement and the rules of private property owners still dictate how you should behave in the real world. Third, the fight is just beginning, and you need to keep paying attention to your state and local government to see how they try to navigate these new rules. Stay informed, stay cautious, and keep learning. This matters to you because your rights are the foundation of your safety and your ability to look out for the people who rely on you. Understanding the law is not just about keeping yourself out of jail. It is about having the confidence to live your life, to protect your family, and to participate in your community without being held back by fear or confusion. You are doing the hard work by staying educated, and that is what makes you a true asset to your family and your neighbors. Never underestimate the value of that knowledge, and never stop pushing to understand how the world around you is actually functioning. The road ahead is going to be complex, and there are going to be more headlines, more debates, and more confusion as we wait for the final outcome of these cases. You are going to hear all kinds of voices, and many of them will be trying to sell you fear or false comfort. You now have the perspective to cut through all of that noise and to focus on the facts that actually matter to your life. You are ahead of the curve because you are paying attention, and that is an advantage that will serve you well in the coming months and years. We are going to be right here to walk through every step of this, so you don't have to worry about missing anything important. As the details emerge, and as the state reactions start to pile up, we will break down what is happening and what you need to know to stay safe. There's a lot to watch, and we are committed to giving you the clear, honest, and practical information you need to handle whatever comes next. Stay ready, keep your training sharp, and keep your mind focused on the things that you can control, because that is the best way to handle any legal uncertainty. If you are someone who believes that staying informed is the best way to protect your rights, then you belong in this community. We are not just talking about the law, we are building a mindset of preparedness and understanding that helps us all navigate these difficult times together. Join the conversation by leaving a comment below with your thoughts on how your local community is handling these carry issues, and make sure you are subscribed so you get the latest updates as soon as they break. We are in this for the long haul, and I will see you in the next one.